This is a paid advertisement. The opinions and views expressed belong solely to Farah Farah and not to Action News Jax, its employees, agents, representatives, or affiliates. This program is informational only and does not comprise legal advice. The airing of this segment is neither an endorsement nor an expression of an opinion of any kind by Action News Jax. This is Legal Live, sponsored by Farah Farah, local lawyers unfiltered.
And welcome to Legal Live, a show aimed at helping you understand and overcome legal issues that are affecting your life. I'm your host, Action News Jax, Ben Becker. Joining me this morning are two of the most famous legal minds in Florida, North America, and the world. Eddie and Chuck Farah, partners at the law firm of Farah Farah. Good morning, fellas. How you doing?
Hey, Ben.
It's good to be here, Ben. It's good to be anywhere.
You know, I thought you were on SpaceX this week, so I didn't know whether we were going to have a show or not.
Yeah, no, I'm looking at that, maybe next month.
Okay. All right. Good. All right. So let's hop on in, shall we?
Sure.
Okay. So
what's on your mind? Let us know.
You know, I've been thinking about stuff. You know, I was driving into work this morning, and I thought, I said, Ben, could you be held liable if you leave a bad review at a restaurant, hotel, or business? Could you be sued for libel or defamation? This kind of just crossed my mind.
It's a good question, and so we get that a lot, and you can be sued because there are two components to that. A business can sue a customer for defaming them, for saying something false that damages the business. So I guess you could argue, in addition to it being false, there has to be some damage. So I'm assuming the restaurant's going to say, maybe some customers looked at that and didn't come to my restaurant. That may be a difficult thing for the restaurant to prove, that how are they damaged by the bad review. But anyway, that's a component, and you can still be sued, but they've got to prove the damage, that they lost something as a result of that bad review. What you should do, my advice would be to stick to your honest opinion if you're giving a review. Make sure the review reflects your own genuine experience, and do not exaggerate your experience once you give the review. And if you've got facts, back up the facts with evidence. That's what you've got to do. Stick to your opinion, or if you've got some facts, back it up with evidence. Otherwise, you're subjecting yourself to a lawsuit.
Yeah.
But there are other. But can I go on? Because
you can go on, man. It is your show. Defamation stuff.
There are certain privileges. Yeah, you go online, you can be sued if you give a false. If you misstate the facts and you don't present the evidence properly, yes, you can be sued. But, a lot of times, there was a recent case, Ben, where a doctor who was working at a hospital was fired from the hospital because people were complaining about that doctor, saying he didn't want to treat the older people. He wanted to delay the surgery. He was very rude to the nurses. He was using foul language. And so they brought the doctor in and they fired him. And the doctor turned around and sued the hospital for defamation, and because this is all lies, I didn't do any of this, and he received a multi-million-dollar verdict on that case, but the court threw it out because there's an exception, there's a privilege that when your employer is reviewing you or you're reviewing your employer, these defamation laws do not apply. So if your employer is saying things about you that are not correct, it's going to be very difficult to sue the employer for defamation, because the court wants people to be able to relate information back and forth about their employment situation. If every employer would face a defamation suit every time they said something about an employee, you can see what would happen. But I just thought that was an interesting case that happened here in Florida not too long ago.
So if I posted a review and said a restaurant, the food tastes like dog food, that could get me in trouble.
Unless you had evidence to back it up. It's your opinion. That's your opinion.
Only if I've eaten dog food before, then I can make that comparison.
Yeah, how would you know exactly?
Right.
Got it. That would be a more difficult case, because it is more of, it's not specific, and I think that would be a tough one to prove. But, if you went in there and said, I went in and there was all kind of foreign objects in my food and it's not true, then that would be something that would be a more reasonable case to pursue. And then you'd have to, but then like Eddie said, the damages. If the restaurant's keeping track of their revenue and there's an, extreme change in revenue after that comment is made, then that difference is the damages.
Yeah, you got to show some damages. Again, back up the facts with evidence, or stick to your opinions, because an opinion is an opinion. This is not my favorite. An opinion is not defamation. I don't like. This is not my type of food.
Or it's dog food. That's
my opinion. I would argue that's my opinion. It doesn't taste good. Okay, that's a personal thing. That's not defamation necessarily. But if you start talking about, there's flies in the food and this sort of thing.
But if they served you Alpo when you ordered, meatloaf, then that's defamation.
But I think this defamation thing, getting back to the lawsuit with the doctor, I think, because people encounter that all the time with employers. Employees are saying things about you at work. And maybe the employer brings you into the office and says, here's what they're saying, and I'm going to have to write you up for it, or maybe, we're going to have to fire you for it, and it's not true. You really don't have a defamation claim against the employer because of this privilege when it comes to employment, because of the relationship you have with your employer. The law carves out exceptions to defamation and slander. And that's why this doctor's lawsuit, although he had won a multi-million-dollar verdict, was reversed and thrown out because what they were saying about him was part of this employment situation.
Got it. Hey, by the way,
I think you run into that more than you do. To me, knowing that is probably more relevant than leaving a review about a restaurant. But that's my opinion.
Okay. Hey, by the way, if you have some questions out there, you're watching us on Facebook, send us your questions. We want to answer some of those as well, in addition to these questions that we have here. And I want to ask you another one, moving along. How many people do you need to file a class action lawsuit? Are there certain benchmarks you have to reach?
Yeah, there are. I mean, first of all, class action lawsuits are people who have either the same injury or the same financial loss. Okay, everybody has purchased this type of dishwasher and there's a defect. It's a defective dishwasher. Or everybody took this particular drug or used a particular medical advice and they have the same injury. That's what makes a class action work. If you've got different injuries or different financial losses, it doesn't work because it's a commonality that makes it happen. But generally, you need at least 20 people to have a class action. And a lot of people say you need at least 50. But at least 20, you're okay, because if you have less than 20, what the judge is going to say, just go file your individual lawsuits. If there's only 10 people who've been affected, there are only 10 people who purchased this dishwasher and it's defective, let them each file an individual lawsuit and not pursue a class action. But
like
the class actions are very, the class actions, are really work when the damages are small, because typically people, if your bank is cheating you, overcharging you $1 a month for some particular bank charge, it's going to be difficult for you to go file a lawsuit on that. Most people will not do it. Okay, and the bank figures, well, man, $1 per account times 10 million accounts is a lot of money to the bank. But with a class action, a lawyer will take that case, and he may have hundreds of thousands of clients. So then it becomes worthwhile to pursue it, because the attorney gets paid from the bank, from the wrongdoer, and the customers will be reimbursed what they lost.
Hey,
we get.
You also maybe sue for punitive damages too, treble damages. Let's keep it going.
Yeah, well,
it adds up. Yeah, you're talking. That's poetry to us. Treble damage or quadruple, because there's got to be something more than treble.
All right, let's move it along.
Let's get on. Let's law on that.
All right, I have another topic for you guys. So, can you sue a school district if a school resource officer allegedly uses excessive force against a student?
That's a good question, because when you asked me about that, I was thinking about what happened in Parkland. Because yes, you can sue the school resource officer, but you're limited by sovereign immunity. Okay, you've got a $200,000 cap on that, because if that person's employed by the state, then he receives the sovereign immunity limits. which in Florida are $200,000. But if you remember the case in the Parkland shooting where the security guard was sued in that case again, but they went after him personally, and they were able to get around the $200,000 cap because of his willful misconduct. In that particular case, that school resource officer, who was a security guard, knew that knew about the shooter because he had commented like a year before that if anybody comes here and causes problems, it's going to be this guy. And he saw the shooter get out of the car and with a gun bag, but he said he didn't want to do anything that was going to cause a big ruckus when it was nothing. And he just didn't think it was an urgent situation. So he didn't think it was a code red. But so they sued him not only for the $200,000 cap, but he was sued personally because of his willful conduct. And so there's a second component to what your question is. The sovereign immunity, the limit of 200, but if you can prove willful conduct on the wrongdoer, then you can sue him personally.
And remember to keep sending us your questions, by the way.
Huh?
And I was going to say, for everyone watching, be sure to keep sending us your questions on our Facebook page. Do you want to add to that or not, Eddie or Chuck?
Although I just think the sovereign immunity, the cap was something that most people don't know about. Let's say
you can also you can go get a claims bill also. I mean, to get over and above the 200,000, it takes Congress to approve. Sometimes you go get a jury verdict against a municipality or the government for more than 200,000. Then you can go to you can go to Congress and the state of
you go to
the local Congress and get approval for them to pay the full amount.
Yeah, those are very
tough
rare.
though.
If you look at them every year, Tallahassee rarely. I mean, they pass maybe 2 or 3 a year over the $200,000 cap.
Right.
Anyway.
Let's talk health privacy laws, shall we? As a consumer, what are you entitled to under HIPAA?
This HIPAA, people talk about HIPAA, they go, it's all about privacy. Well, that's an important component of it, not releasing medical information. If they do, there's some financial penalties. I mean, if you can prove that for every violation, if it was an innocent mistake, it's a $100 penalty. If it was a willful type mistake, it's $50,000. So the money, it can add up when it comes to these HIPAA violations. But the other components of HIPAA are that if there is a breach of your medical information, whoever has the information, healthcare provider, whoever it is, has to report it to the patient if it poses a significant risk of financial, reputational, or other harm. So anytime there's a breach by any of your medical information, they got to report that to you, okay? And then you can look at, was it a willful breach of my information? Is it a $50,000 penalty, or was it just a mistake and it's a $100 penalty? So, but the next important part of that HIPAA law is that, this is what I think is never heard before, it's kind of interesting, that it allows patients who pay for full for their medical treatment. Let's say I want to go in and have some sort of medical treatment, and I pay for it out of my pocket. If you pay for it out of your pocket, you can require that the hospital or whoever does the surgery or whoever's involved, to not report that information to your healthcare provider. So your healthcare provider would never know that you went to the hospital and paid out of pocket to have some sort of procedure done or surgery. And you can require that to happen.
That's interesting, too, because when you pay for it yourself, sometimes it's cheaper than using your insurance. That's a whole different topic, but I thought that's interesting.
And plus, you may not want your health insurance to know that you had this procedure done, which may affect your rates.
Very interesting.
Yeah, that's the
so
big reason.
You can do it if you want to pay out of pocket, which is interesting. The other thing is, under the High-Tech Act, you can, it used to be, Ben, people who wanted medical records would have to pay a fortune to get them. They would charge you $1 a page. Imagine, you're in the hospital for 5 days, you're going to have thousands of pages of records, which means you're going to have thousands of dollars, $1,000, several $1,000 bill to get your medical records when you need them for whatever reason. Now, under this HIPAA law, you're entitled to request all your medical records electronically, okay, which means they got to give them to you in a PDF or whatever CD, and there's a limit to what they can charge you. It's pennies compared to what it once was.
Of course.
And that the reason that was is because hospitals and doctors and medical providers used to make a fortune. They would sub out the medical records part of their business was one of their biggest money makers because they could charge $1 a page. Imagine.
Now, of course, we all give away our information. Now we give away our information on apps. That's, I guess, a different story for a different day. So let's talk about small business owners, okay? This is for them. If a customer has some sort of medical incident, what is your legal responsibility?
What are you supposed to do? And the case I was looking at was a case at a gym where there was a gentleman on the Stairmaster. He's working out. He has a heart attack and he dies. The family sues the gym because they didn't have anyone there who was qualified to perform CPR. They didn't perform CPR, and they didn't have a defibrillator there. And the court said, in that case, all the gym was required to do what was reasonable under the circumstances. And reasonable under the circumstances is calling 911. That's all they had to do. Now, you may, a legal duty is different than a moral duty. As a human, you may think that it's different. There was another case where a guy was drunk, passed out on a pier, and the pier owner kind of just stepped over. He was laid out drunk on the pier. The guy rolled over and drowned in the ocean. And the pier owner was sued because he didn't do anything. All he did was step over the drunk guy who was laying on the pier. And so the court said, you're required to take only what's reasonable under the situation. And reasonable is not doing anything. He should have called 911, and then he would have probably not been sued. But
did they make a recovery on that, though? Because that's tough. You create your actions. Our actions create a duty. So going back to the gym.
But he was a customer at the pier.
Right, but going back to the gym, if I had a defibrillator there, and no one knew how to work it, now you've created this duty that, hey, if something happens, I gotta use this defibrillator in the right way and use it the way it's supposed to be used. But if I don't have one there, then there is no duty. So it's our actions or what kind of create the duty under the law.
Interesting. All right, we have viewer questions. All right, you guys ready?
Yep.
All right, Brittany, Brit. I did an investment with my money and never got anything out of the investment. What can I do to get my money back?
Well, it depends how much money's involved. If they've recently raised the limits for small claims court as of January this year. So it depends on how much money you're out of. Can we ask her? Is it more than
I think
$20,000, more than $15,000?
Well, I think it comes down to the risk that she agreed to take on with that investment. If she said, listen, I want to be aggressive on this, and I want to make 40% on the investment, and she lost it all, well, it's probably not, there's not a claim there. But if she communicated to the broker or whoever made the investment for her that, hey, I really want this conservative, I want to earn 3%, and she lost it all, then there might be a claim there. So it really depends on the circumstances and the agreement you've made with the broker.
Yeah, if it's a brokerage type situation, also, you have to be aware that there's probably an arbitration clause in there. 99% of them have it. So I don't have enough information. I got to know the amount. I've got to know if it's a brokerage account. Is it just I invested with some individual? I invested in a restaurant.
If it was like a regular broker, you could file a complaint with FINRA, right? Wouldn't you be able to have some protection there or no?
Yeah, but you've got to go through, it's still going to be an arbitration. You're going to go through an arbitration. Those brokerage agreements all have arbitration clauses. I've never seen one that doesn't, which requires you to go in front of 3 people. She picks an arbitrator, the brokerage company picks an arbitrator, then those 2 pick a third arbitrator, the third one. And you go in front of you have your day in front of the arbitrators.
Right.
And they determine whether you win or lose. But I don't know. I needed more information.
Right. No, I get it. All right. So Sally has a question. How do I collect a judgment from winning a small claims civil lawsuit?
Okay. It's a good question. We get it all the time. I guess, we're personal injury lawyers, but we do, kind of learn a little bit about that other stuff too. But if she has a judgment, okay, if she has a small claims judgment, she needs to record a certified copy of the judgment first. Once she records a certified copy of the judgment, and it can be certified at the courthouse, they'll put a stamp on it, then that judgment becomes a lien against all the property that person owns. So if that person goes to go apply for credit, that judgment's going to come up. If they go buy a house, they do a title search, that judgment's going to come up. So that person may come back to you and say, hey, I'm trying to buy a car. This judgment is ruining my credit, or it's resulting in a very high interest rate on the vehicle. A lot of times they'll reach back out to you and say, hey, let me pay you so I can satisfy the judgment and get it off my record. If they don't want to do any of that, then you could hire an attorney, and there's a process to go through where the sheriff will go out and execute on their property. Maybe they've got a vehicle, maybe they've got some land. So I mean, you can go after their bank accounts. You can bring him in for a deposition, ask him to bring all his bank account information to see where he banks, see how much money's in his account, and you can go after the money that he has in his name.
Yeah, but Eddie, let me jump in. Now, if the claim is for a few grand, to hire an attorney, it may be cost prohibitive to even go that route.
But don't forget, once you record it, okay, it's a lien against them. If God forbid, if there's an estate, he dies, they're going to have to notify you that, we know you have a judgment, and that judgment gains interest every year, and so it gets bigger.
I think it needs to be renewed, though. It doesn't need to be renewed.
I think it's good for like 15 or 20 years to renew it. But you can renew it, and it just grows, and it grows in value. So, but there are lawyers in town, Ben, that's a good point. There are lawyers in town that work on a percentage. They'll take your judgment, and they will go collect it, and they'll take a piece of the action instead of charging you for it. If she needs a number for that, she can call me at the office, and I can give it to her.
867-5309, is that the number? No.
You're still living in the 80s, man.
Oh,
it's okay.
right.
All the numbers we don't know.
Shantea.
I thought you were a lot younger than that.
Well, I just turned 29. Yeah. Shantea, she has a question. Can I sue a doctor for messing up my surgery, causing more surgery and tons of pain? What do you think?
Yeah, I mean, it depends.
We had this question before on the show.
It just depends on the procedure. I mean, listen, doctors have boundaries that they have to stay within when they're doing a procedure. And there are sometimes side effects to procedures that are reasonable and aren't negligence. They just happen. So you almost have to get an expert to look at, what happened, and if, the doctor performed something outside those boundaries, that are established by the profession, then you can sue. And you can, if there's negligence there, then you can sue a doctor. Now, a lot of it depends on the extent of damage.
If you don't have a permanent injury.
That's right. So it's
not going to work.
Well, that's what I was getting into.
Yeah.
You got to have the damages and a permanent injury in order to pursue a claim.
If a second surgery can fix the first surgery, I doubt if you have somebody who's take that case.
Well, she's got medical bills. It depends on, that maybe those are the damages that you go after. But again, they're expensive cases to pursue because you have to go out and get an expert right off the bat, a doctor, out of the area typically, that will give an opinion that the doctor performed negligent, or, he was negligent in performing the surgery. And, that's a big investment right up front. So you've got to make sure you got a good case there and that the damages weren't.
On these medical malpractice cases, there's two components to them. You've got to have somebody you got to have a negligence. You got to show that a doctor, what he did was below the accepted standard of care. And two, you got to have a permanent injury. Without those two components, you really don't have a case. So what I'm saying is, if you can prove the doctor made a mistake, but a surgery can come back and correct that mistake, and that surgery costs $50,000, it's a lot of money. How come I can't get my $50,000? But I'll tell you, it's very difficult because when there's no permanent injury, the lawyers will not get involved in these cases.
Got it. It's funny, you keep bringing up this whole thing about evidence in these cases. Like, you need evidence. It just kind of gets in the way,
It does. Sometimes, I wish we could make our own evidence.
Yes. Hey, let me ask you this one.
Can we fabricate some evidence?
Well, no, we don't want to do that. We don't want to do that. So let me ask you this one. This isn't The Wire. We're not making up any evidence. So this is another viewer asking, can you be evicted from a hotel if you're suspected of having the coronavirus?
Listen, I'm off the top of my head, and I don't know any law backing this up or anything, but I think you would. It's a private property. If they're a danger to everyone else that's there, then you probably can. I mean, typically when you're dealing with private properties, you can set the rules any way you want to and be fine with it legally. And I'm not sure that's 100% true, but I think in this situation, they'd be able to evict if they think that it's going to cause a spread.
Got it. All right. Hey, Carolyn wants to know, can you sue the post office for discrimination?
Under like Title VI? I mean, like I think it's Title VI. Yeah, based on religion, race. Yeah, you could, of course. I mean, I don't think they're exempt. I don't think they're exempt from that federal statute.
I don't think there's a cap either, like we talked about earlier.
Yeah.
Okay. All right. That's good stuff, guys. Appreciate it. Anything else you want to add? Quick final thoughts?
Well, I mean, I could get into the slander thing. There was some interesting stuff going on with slander and all that. But I mean, it'd probably take another few. I don't know how much time we have, but probably don't have much time to.
Yeah.
No. You got 30 seconds.
There's not enough time.
You want to slander me? Go ahead. You got 30 seconds.
Yeah, well, there's an interesting law in Florida called the anti-slap statute, and a lot of people were getting sued. Let's say there's a developer, and he wants to go out and he wants to like mow down this forest and build this big development, and you get up there and you're in a public hearing and you're going after the developer and saying all the bad things he's doing. In the past, they would come back and file slander lawsuits against these people to shut them down. Not because they wanted to get any money from them, because they wanted to wear them down and say, you got to go get a lawyer, we're going to sue you, we're going to get a judgment. So now there's a law that protects people who speak out in the public interest, who express opinions such as that, to maybe talk about the bad things the developer is going to do to the land. And so you have some protection.
That's a good law.
Yeah, it's called the anti-slap statute.
That's a good.
Well, you know, I would never slander Farah and Farah. I'll tell you that much.
Okay.
Never ever, because I don't want to get sued.
No
Hey, if you have a legal question you'd like answered on our next program, send us an email to legalive@actionnewsjacks.com. Hey, thanks again for watching. For Eddie and Chuck Farah, I'm Action News Jack's Ben Becker.
Thanks, guys.
This is a paid advertisement. The opinions and views expressed belong solely to Farah and Farah and not to Action News Jacks, its employees, agents, representatives, or affiliates. This program is informational only and does not comprise legal advice. The airing of this segment is neither an endorsement nor an expression of an opinion of any kind by Action News Jacks. Thanks for watching Legal Live, sponsored by Farah and Farah, local lawyers unfiltered.